Hello everyone, I welcome you all to another video by Legacy IAS where we are going to talk about a judgment of the Supreme Court that has come today, a judgment that was awaited by many in India and hopefully some outside India as well. A judgment which kind of also helps us understand or takes a step ahead to understanding in which direction is this Indian society moving. In which direction are we trying to look at our ideas and principles of religion and secularism? How does the state perceive or how does the state reinstate its position, its secular credentials in the country? This particular verdict is not as decisive as the entire country was probably expecting it to be, but we still have to wait and watch as to what it goes ahead. But it still holds some important insights and gives us some important takeaways as far as India's understanding of the entire idea of religion is concerned, with particular focus on a community which has been in news for quite some time now. We're talking of the judgment with regards to wearing of hijab, with regards to wearing of the scarves, which is particularly associated with the Muslim community. So as far as the Supreme Court verdict is concerned, we're going to look at it. Let us see how this entire issue began. If we look at the entire issue here, it basically was something that cropped up in December of 2021 when some students were actually denied, some students who were wearing hijab, okay, some girl students of course who were wearing hijab were denied entry into a classroom in a college in Udupi, which is in Karnataka, on the grounds of violating the prescribed uniform code. Now, every school generally has a uniform to follow by, but here we're talking of a college. All right, and in a college there was a uniform code in Udupi and that was being violated according to the authorities and officials on the grounds that the girls were wearing hijab. So this particular group approached the college authorities in order to look for some kind of an understanding and some kind of settlement that could be reached, and mid path could have been followed, but nothing really much came out in this particular direction. Now, before we move forward into understanding what happened as a result of this particular issue, let us look back and look into some of the other rulings by the judiciary which has come up on this particular issue prior to the 2021 incident. So, this particular case we're talking about is actually something which took place or which was decided by the Kerala High Court. The case ruled as Amna bint Bashir versus CBSE in 2016, where the Kerala High Court upheld this practice of wearing the hijab as an essential religious practice. Now, these three words are basically one of the areas where this entire issue lies, that whether or not hijab is an essential religious practice. Is it mandated for you to wear it? Okay, we're going to come to that why is this particular element so very important in this entire discussion and narrative. However, students wearing full sleeves could have been examined wherever needed. So it did give, some kind of safeguards in the sense that still if full sleeves were being worn for safety reason and for checking and security reasons, you could still, have some kind of examination if required. But otherwise, it is an essential practice of the community. Also in 2018, we had Fatima Tasneem versus State of Kerala, where the Kerala High Court said that the collective rights of an institutions have to be given primacy over individual rights of the petitioner when the petitioners were two girls who were basically wanting to wear headscarves. So what the Kerala High Court said that it's basically you have to look at the institution as a whole, and the interests of two girls particularly cannot be upheld. So even though the first judgment of 2016 was something which was very decisive, the second one is more like trying to be much more accommodative, trying to have a majoritarian outlook, or for that matter, trying to have an outlook which tries to promote social order. All right. There is one thing which should draw our attention towards. If we look at the entire discussion of burqa or hijab, for that matter, we should kind of go back in history and look at the time that, as far as linguistic history is concerned, okay, the word burqa was in use in Arabia even before the advent of Islam, all right, in the 7th century. At that time, this word was basically meant to be a piece of clothing that was used as a protection during winters. There is one thing which we all need to understand at this point of time, that things in society seldom come out of thin air. What I mean to say is that there is a context to these practices which come up in any religion. Alright, so here the context in this scenario was for protection, especially during winters. Also, it's not like this particular word or terminology did not exist in Arabic vocabulary, but if we look at the Quran, okay, so Quran did not use the word burqa to refer to as women's parda. This kind of concept of burqa actually became Islamized and also became a part, more importantly, of the Muslim culture. So there is one thing which the religion propagates, or for that matter, there is one thing which are there in the philosophy, which ultimately become a religion through some practices and through some cultures which are incorporated into it. So time and again, when we are troubled with such major issues, it's also very important to be rational and try to think of from that perspective. So as far as Muslim culture is concerned, it's a social phenomenon. Whereas if you look at Quran, it is the book of God which is basically, revealed to the Prophet of Islam, and the source of Islam is actually the Quran and not the Muslim culture. Alright, just in terms of putting things into perspective and looking from a historical and scientific perspective, this is what we get out of looking at the history of burqa. Now, when this entire incident happened in Udupi, in Karnataka in 2021, it was actually responded by, in January of 2022, by some Hindu students in Chikmagalur who demanded that they be now allowed to attend classes wearing saffron shawls. So it's not just an element of wearing an additional piece of clothing, it's also getting associated with a certain color. Alright, several institutions across the state witnessed protests by the student over this particular dress code. Some Muslim students moved the Karnataka High Court in what we popularly known as the hijab case, is actually Resham versus State of Karnataka, which was basically contending that wearing of hijab is a necessary religious practice, alright, and barring it is basically amounting to discrimination, hostile discrimination on the basis of religion. So it also argued that the fact that there is no law which kind of bars you from attending classes in hijab. Alright. Now, what we also further saw was that the state government stepped in on February 5th and issued an order whereby clothes were banned that disturbed equality, integrity and public order in schools as well as colleges. So essentially what the government came out and said that we need to have or need to stand by principles of equality, integrity and public order, and if there are any clothing which kind of disrupts that, then that has to be banned. So the Karnataka government maintained that wearing of a hijab was not an essential religious practice. Alright, so it did not really treat that as an essential religious practice. On 15th of March, the High Court of Karnataka actually dismissed all the petitions and ruled that hijab is not an essential religious practice within the Islamic faith. This particular judgment, refusing to lift the ban on hijab in the educational institutions of the state, actually took it a step further. Alright, if we look at the entire issue and we see that what are the arguments that are going or favoring this wearing of this clothing or this hijab, Supreme Court also during its several sessions and proceedings went out to say that restrictive practices could lead in dropouts. Now what we should understand at this scenario is that dropouts and education for the judiciary is much more important than giving primacy to any such religious identity, any such religious symbol for that matter. So what it feared or what it anticipated during the discussions that when we put such restrictions, they feared that it might lead to some dropouts. What the community says favoring hijab is that you have other religions who also wear symbols like cross, and bangles are often being worn by the Hindus in the classes, all right? So this kind of an instruction that you're giving, it's almost like a stepmotherly behavior by the government authorities, which is basically preventing the students from practicing their faith. And it is resulting into what? Unwanting law and order situation. So it's almost like the kind of action that the government is taking is what is probably leading to further law and order problem. Also, if we look at the 2017 judgment with regards to right to privacy, it also says that identity, dignity and self-determination are actually inalienable rights of the individual. And you cannot force a girl, you cannot force someone, a student, to be compelled to surrender her rights, her inalienable rights at the school gate. So these are the arguments which are favoring this particular judgment, or rather this particular wearing of the hijab. Now, when Supreme Court has essentially stepped in, all right, when the issue has been brought to the Supreme Court, today it basically passed split judgment. It passed a split judgment how? On appeals, all the appeals which were basically challenging the restriction on Muslim girls, on the Muslim girl students wearing hijab in educational institutions in Karnataka. So the first opinion which was shared by Justice Sudhanshu Dhulia, he actually allowed all the appeals and said that it was a matter of choice of Muslim women, all right? Nothing less and nothing more. It's just a matter of choice whether you want to wear it or not. Now the sad part in reality is of course the fact that often it is not a matter of choice but a practice and a tradition which is being continued. Had it been a matter of choice, things would have been probably much different. This entire concept of essential religious practice, in my opinion, meaning in Justice Dhulia's opinion, was not essential for the disposal of this dispute. So he said that unnecessarily you're trying to put in a religious concept which was kind of uncalled for and you could have done away with. He also said, in fact, he said that there's a different view to the entire thing. He's allowing the appeals essentially because he's allowing the appeal against the judgment, High Court judgment, essentially because it is ultimately a matter of choice. If you do it because you want to, then you are upholding your right to liberty, equality, privacy, and that is where it should be protected. So Justice Dhulia said venturing into essential religious practices was not needed. Alright. So in a way it said that the High Court kind of took the wrong way. So that's what Justice Dhulia is saying. But we have an alternative opinion in this regard. We have Justice Hemant Gupta, who actually dismissed all the appeals which were there against the judgment of the Karnataka High Court. He went on to say that hijab is not a part of the essential religious practice under Islam. And the Karnataka government order serves the purpose of access to education. They are trying to have equality in all forms. The whole idea of having a uniform in the first place is to do away with any kind of discrimination, any kind of differences in terms of identities of rich or poor, scheduled caste, scheduled tribe, Adivasis, religions, etc. They all kind of brought together and you have this one uniform which reinstates the principle of equality among all the students so that the focus is on education and not on anything else. All right. So in that sense, this opinion was given, and a lot of questions have been put forward by him, which actually creates a food for thought. Now, whether the college management can decide on the uniform of students, that is something to ponder upon. Whether restrictions on wearing the hijab violates Article 25 of the Constitution. What is the ambit and the scope of freedom of conscience and religion under Article 25? What is the jurisdiction of this particular article? What is the ambit and the scope of essential religious practices under Article 25 of the Constitution? All right. Also something that whether fundamental rights of expression under Article 19, Clause 1, Subclause A, and the right to privacy under Article 21, are they mutually exclusive? Are they have to be said or read or understood, separate from each other, or are they complementary to each other? Whether the government order meets the test of reasonableness under Articles 19 and 14. Now, those of you who have gone through the rights of the fundamental rights, and especially right to freedom and equality, you know that it is subject to reasonable restrictions, all right? And there's a list of reasonable restrictions with regards to sovereignty, territorial integrity, all right, morality, public order. So does it meet the test of reasonableness? Whether the government order impinges upon constitutional promise of dignity and fraternity. These are some thoughts which, Justice Gupta has kind of brought forward. He's raised these questions, and now it is upon another bench of the Supreme Court. Hopefully it will be the Chief Justice of India getting into it, where we have to really wait and watch as to how it is taken forward. So as of now, there is no stay by the Supreme Court on the verdict, and Karnataka High Court's order is going to be continued. We will have to look at the Chief Justice to constitute a new bench, all right, having at least 3 judges. So according to the information we've received from the Supreme Court, it says the new bench will start hearing afresh in view of the divergence of opinion, all right. So the Supreme Court has asked the matter to be taken up before the Chief Justice of India for the appropriate directions. Now we'll have to wait and watch and see how this entire situation unfolds, what perspectives are accommodated, what is the idea or thought of the Supreme Court in this regard, and what the future with regards to concepts like symbols in religion and our secular credentials are taken forward. So I really hope that you've enjoyed this videos. We all will be waiting for the Supreme Court judgment in this regard. Till then, you can like and share this particular video. Thank you so much.